About the re-indictment. I'll just take care of that.
It's a mess.
It was.
I tried.
It was pretty convoluted.
All right, you're Carly Davis and Carly Hoosier, and this is 24 DCCR 1385 and 25 DCCR 1237. And so their state has, we were going to be here on reviewing bond conditions, correct? And then the state has filed a motion to increase the bond.
Yes, Judge.
And is that in both of the cases or just that one?
In both cases, Judge.
Let me pull this up. I know I took a look at it last week, but
This one's charged.
and so we've got both of these cases are driving while intoxicated, third or more. The first offense date is from May 6th of 2023. The second from February 10th of 2025. Give me just a second here. No, it's working. It's just working slow. So I've got some history with regard to prescriptions. Some of it's obviously very hard to read, but it looks like prescriptions for alprazolam and something called D-amphetamine. Okay. Can't tell the date. One of them specifically says no refills. I can't read the dates on this.
We can get better photos, Judge. She has had that prescription for,
All right, it shows it expires October of this October 31st for the,
Judge, I had a number of questions about those photos myself. I mean, I'm not necessarily, well, I guess I am questioning the validity. This doctor that allegedly prescribed it, this Rajan Desai, there's either an Austin address or a Millburn, Texas address for this doctor. When I looked him up through the Texas Medical Board, and I'm just a little curious about.
so where do you go to the doctor? Where's this doctor from?
From Beaumont, and I do a telemed every month except every 3 months. I go to his office now. I have an appointment with him today now.
Today?
Yes, ma'am.
Where specifically?
Telemed today.
Oh,
Yes,
well, here's what I think I'm going to do based on the nature of what these medications are and the history. Well, are you driving? Okay, I don't know if I already did, but a condition of your bond is going to be, as of today, that you are not allowed to drive any vehicle ever, period. Okay, so if you're caught driving, obviously you'll be right back in jail without, probably without a bond. Mr. Coleman, other than a no driving, is there any other?
No, Judge, I just would like to reiterate, and we put it in our motion, and it sounds like the court's read the motion, but, she's got 4 previous DWIs, Judge, and in addition, she picked up this latest DWI while out on bond for a DWI, Judge.
Right.
And that along with the positive drug test, I think the public safety, the community safety demands some additional assurances.
And Judge, our argument would be that the DWI itself is for the medications. She's been on these medications for.
Well, it doesn't matter if you're on medication and you're
Right.
taking too much medication, then that's a problem.
Sure.
So you can be on these medications and not be.
Also, the failure of the drug test was for these medications.
Right, I understand that. My biggest concern is the fact that if the medications are not being taken properly or too much of the medications, then that's a larger concern with the safety, and I completely understand and agree with Mr. Coleman on that. How'd you get here today? Here's what I want you to do, what I'm going to order you to do. I'm going to order that at your appointment, I'm requiring you to find out and with your doctor, get a prescription for something that is non-narcotic. So something that is not going to cause these issues if in fact our concern is that you are misusing or overusing these medications, then there's other medications that you can take. You need to talk to him today. I want you on your way to be off of both of these medications and on something that would not lead to the issues that you're having. Does that make sense? You need to get that information from him, find out what he can prescribe. I want those to Ms. DeLage, and I want her to get those to me. That is a condition of your bond at this point. If you don't do that today at that appointment and get that information to her, then I'm going to, what I'll do today is not rule on Mr. Coleman's motion, so that motion to raise your bond is still out there. And if you don't get this information and you don't get this done today, then your bond will likely be raised and you'll be in jail. Do you understand? All right.
My only question is, the medication to get off of it abruptly can cause.
I understand that. I'm not saying you have to get off of it abruptly. I'm saying I want the plan and how you're going to do it, what it's going to be reduced to, what it's going to take its place, whatever it is. I want that. You need to tell him that you have been ordered to get off the medications, but obviously that needs to be done in a medical way, but I want whatever that plan is and how you're going to do that, and I want that to Ms. DeLay so she can get it to me tomorrow. Okay? All right, y'all are free to go.
Thank you, Your Honor.
And Mr. Freelo is charged with murder, and Mr. Galmore, Mr. Nichols, what's the announcement?
Judge, I don't think we're ready to set this for trial yet. I know it seems like every hearing I tell you there's stuff we need to investigate and find out, and there is still in this case. There's a potential witness who has given unsworn statements that has basically blown off appointments to give a sworn statement, and we need to run her down.
That's what we were going to do last time.
And they made appointments and she didn't show up.
Well, if we're talking about that one witness, she did meet with the investigators between.
Okay.
But there's also a new witness, another witness.
Okay.
And possibly some video footage that was deleted that I believe the Port Arthur Police Department is trying to get their hands on.
I need to check the status of a subpoena for that video. We need a little more time to it.
Okay. All right, we'll just do a normal reset. Y'all can work on that. We'll see where we are at the next court date. Mr. Freelo, make sure you stay in touch with, did you have something else?
I could, yes, Judge. I don't have a motion necessarily on file, but Mr. Freelo currently is on house arrest with a GPS device. His wife has recently been unable to return to work to the federal prison, so their income is limited. He's trying to find a job. It's been difficult, obviously, with thing hanging off of your ankle and whatnot. So we were asking the court if the court would consider removing him from house arrest and GPS requirement.
No to both of those things, but potentially to, the GPS is going to remain on. I would consider, Mr. Nichols, what's your position with regard to him looking for work and getting a job?
I'm in favor of that, Judge. But I agree with the court. I think the monitoring needs to stay in.
For now, at least,
Monitor moving from house arrest?
Mm-hmm.
Okay.
Yeah. Wear long pants and cover it up, whatever you need to do. But at this point, I'm not willing to do that based on obviously the nature of the offense. And so if you do this, Mr. Galmore, if you'll just send maybe a memo over and copy Mr. Nichols on it so that I have a paper trail to say that you asked me and that I granted that part of it, and I'll just sign off on a memo. Doesn't need to be a motion.
We'll do
But that'll just remind me to get it in the file so that it's clear. Also, we can send that to whoever has his GPS monitoring monitoring device, so they know it's just for work-related purposes. You can go find a job, go to work, things like that, but it's not just a full-on go do whatever you want kind of
Well, Judge,
release.
actually, that's currently the status. He is allowed to leave only for work purposes currently. But because his wife is unable to work, her medical conditions made it much more difficult for them. So if the court would still consider just removing him from house arrest and keep the GPS, that would probably help a lot with the other life's necessities.
Okay. I know you've asked for him to drive her to this, there's been
Yeah, he had to take
doctors.
him to the airport the other day. But I mean, obviously in life, a lot of things like that pop up regularly, and if he's gonna wear a GPS device, you know, the court will always know where he's at, that's important. But removing him from house arrest would be probably a big help.
Mr. Nichols?
Hard for me to really argue with that reasoning, Your Honor.
Okay, so I am going to require for you to remain in Jefferson County without permission. So if something happens, like the other day with the trip to airport or whatever, get with Mr. Galmore, he'll send me something, I'll approve or not approve. In Jefferson County, do what you need to live your life. I don't want, I mean, that doesn't include going to bars or going out at night
Maybe a
or.
curfew is appropriate, Your Honor, unless,
Yeah, that would be.
I mean, if he ends up with a night job, obviously that's different, but.
So let's do this for now. Let's make a, I'll release the house arrest, remain in Jefferson County with the curfew 8 p.m. to 6 a.m. If you get a job that interferes with, just get with Mr. Galmore and get those hours, whatever the job is, and we'll work around that. But primarily, I want you doing necessities away from your home, and that's it at this point, okay? All right,
Judge.
thank you.
Thank you, Your Honor.
All right, so you are Daryl Spencer?
Yes, ma'am.
And Mr. Spencer has 4 cases, 24 DCCR 1863 charged with possession of marijuana, 25 DCCR 1149 charged with evading arrest or detention with the use of a vehicle, 25 DCCR 1150 charged with unlawful possession of a firearm by a felon, and then 24 DCCR 0841 also charged with evading arrest or detention with the use of a vehicle. And the state has filed motions in those 2 newer cases, cause numbers 25 DCCR 1149 and 1150, to raise the bond in those, or increase the bond. It looks like the current bond in each of those cases is $15,000. The bonds on those 2 previous cases, one was $7,500 and one was $25,000. And Ms. Malfino, you may proceed.
Judge, based on the fact that Mr. Spencer was out on bond, bless you, and then committed at least two additional felony offenses, we would ask, just based on the totality of the circumstances, the nature of the offenses themselves, that the court raise all of those bonds and place him back in custody. And I will provide discovery to Mr. Kimler on the 2 new cases. He indicates today that he's going to be hired on those, but
I have you on all of them, right?
Yeah, I'm on all of them.
Okay, I'll make sure.
If everyone will give me just a minute, I am going to take judicial notice of the court's files and all of the cases, which include the probable cause affidavit in those 2, well, all of them. Give me just a second to.
Just to be clear, the offense dates on the 2 new offenses are after the other 2 offenses, is that right?
Yeah, so the offense dates on the 2, we've got the possession of marijuana offense date of February 15th of 2024, and the evading arrest or detention from March 2nd of 2024. And then we've got 2 new cases, one from June 14th of 2025, the evading arrest or detention with the use of a vehicle, and then June 15th, the unlawful possession of a firearm by a felon of this year. So give me just a second to review all of this, and then I'll let you.
Got time? Just walk through the object.
We make sure we sign it.
Sorry, I should have had these done already.
Maybe it's.
Got one more, I'm coming, I think. Oh, wait, that's what I'm missing. 08. All right, so let's see. On the two older cases, it looks like bond was made May 24th of 2024. So he was definitely out on bond on those when the two new. I should have one more.
Additionally, Judge, he has been before this court before in 2017, as well as next door in the
So we've got, here's the,
We're gonna just go with the Class A amount. When this piles up, it'd be, yeah, it's gonna drag in. So it's not be less than 750. Look, less than 750. Yeah, that should get us to what, Class A or B?
Yes, that's enough.
Let's do A, that's what we'll do.
Thanks, honey.
all right, so the unlawful possession of a firearm by felon and that evading, same offense, or date, pretty much same. And then okay, I should have another one. I should have one. Is there not anything else I printed?
Two of them are the same.
I know. I should have three. These two are the same, but I should have this one and another one. I thought
That's the three printed.
okay, hold on.
Yeah.
All right.
I think I filed them in both cases.
You did. I'm just trying to find the
The same
PCs
PC.
from the, I'm trying to look at the underlying PCs as well. So give me just a second to pull up the, which one is, what am I trying to
Well, it'd be
find?
the same, probably the same PC for
Two
each
same.
case.
Evading.
Two printed.
0841. I didn't just print this one?
And two of them look just the same, but there's still stuff in it. And that's that.
Okay, maybe that's it.
This stuff's just better.
Why did it do two? What's happening? Okay.
I'll sign it out.
So you said he's previously been in other courts. What other, do you have convictions?
I do, Judge, I do have a conviction in this court from May of 2017, 9 months in state jail for engaging in organized criminal activity. Also, it appears that in 2017, he was also in drug court for third-degree possession. It looks like he received probation on that case. There was a knock on that, so I don't want to misrepresent that. He did get 3 years TDC on that, Judge, on revocation, and then in CDC back in 2023, he was given a lesser included Class A deadly conduct where he served 1 year in jail.
Mr. Kimler?
Well, yeah, I'm not prepared to litigate the merits of the two new cases without compromising defense. I suppose the court will have to stand on the PCs. I know that he's employed, is that correct?
He's working on the report, yes, sir.
Longshoreman, and is endeavoring to maintain a law-abiding lifestyle. I believe he could pass a drug test in lieu of an increased bond if the court is inclined to take some sort of remedial measures. Regarding Mr. Spencer's conduct while on bond for the previous two cases, I would suggest a GPS device in lieu of increased bond.
I don't see how a GPS is going to help when you're out on bond. You've got 2 felony convictions, a state jail and a TDC conviction. You're out on bond for a felony possession of marijuana and an evading arrest, and there's an additional arrest for an evading and an unlawful possession of a firearm by a felon. I'm going to, based on the criminal history, based on the nature of the underlying offenses, and all of the factors in 17.15, I am going to grant the state's motion to increase bond in cause numbers 251149 and 251150. I'm going to raise the bond in each of those cases to $100,000. Condition of those bonds, if made, are that Mr. Spencer not be allowed to drive a vehicle, period, on bond, and that he wear a, I'm not worried about that necessarily. Obviously can't have a firearm, but I'm no driving whatsoever. All right, you can go back with the bailiff, and I'll reset the case for an announcement for the cases.
Judge, Mr. Fletcher represented to me outside. He misunderstood what you were asking with regard to the pleas of true and not true, and with the court's grace, if he could change his plea of true to not true on the possession of marijuana allegation in the MTRP.
Mr. Smith, any objection to that? We're going to have a hearing on all of it anyway. So that's in cause number 21, 37809. He had pled true to count 4, and you're asking to withdraw that and have pleas of not true to all counts. Is that correct?
Yes, ma'am.
Okay. All right, then I will make that modification, and again, we'll set it for, get an updated pre-sentence report, as well as I will get with you guys about what we're setting it for in the next couple days.
Thank you, Judge.
All right, you're free to go. Diamond James. Good morning, ma'am. You're Diamond James. And did you get someone hired? Speak up, please.
No, ma'am.
Who'd you talk to?
I spoke with Kyle Walker. He said 7,500, but no payment plans on the down payment.
Okay.
I spoke with his James R. Macon.
Mm-hmm.
They said 7,500 as well. I spoke with Franklin and Associates. 10,000, the minimum is 7,500. 500 every 2 weeks, but the way the work has been going, the hours have not been 8 hours a day, so.
Right. So thank you for doing what I asked you. I'm going to let you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely because you're going to swear under oath that it's all true and correct. So put whatever your bills are, whatever your income is, and then I'll take a look at it. If you step in front of the clerk, she'll give you that, those instructions.
The nature of this plea originally, Judge, was obviously a little bit low. It was based on some cooperation, non-cooperation, cooperation, non-cooperation, which I believe is still the case. I don't know what.
Look this way.
What is, I don't
You
know
look
the
this way.
relationship between the two of them. Obviously, I'm concerned for that. It's my understanding through Ms. Lopez that they're continually together and that in addition to Mr. Bell, she is also violating that no contact order by voluntarily engaging.
I think they got children together as well, is that right?
Well, that's why.
They're pregnant now, is that right?
But that's why I made the specific rule that they go through a third party to transfer kids, to see
And
kids.
the problem is that the third party is his mother, which is, I've told him multiple times, cannot be.
Cannot be. Okay.
It's not working.
You are pregnant with this child right now?
Yes, sir.
Okay.
So here's the thing. I can't necessarily order you. You're not here in court on an offense. But he's going to jail today because y'all won't quit doing what I told him not to do. So it's that simple.
Can I say something? Whenever I did call the probation officer, technically he was already staying at the house. We both our managers are in the house. He was already staying at the house. So when I went to the house, I just wanted him to leave because, me and the kids needed somewhere to go. And I called the probation officer on my own, but he was technically staying at the house already. I just wanted him to leave because me and the kids needed somewhere to go. And obviously we all couldn't be there.
Right.
But he haven't.
So did he not leave so that you and the kids could stay there and that's why you called?
Yes, ma'am.
Okay,
But
then
he's
it's,
been staying there.
all right, well, then you know what you have to do. You're the one
I
on,
got out the house and I waited on my ride before my ride came.
Well, if you're staying at the house
I
and
don't
you're,
stay there anymore. I stay with my this.
I'm resetting it for a sentencing hearing. If there's any testimony at that time, you can recall witnesses and so we'll come back.
Your Honor, I would implore the court to admonish them that contact includes calls from the jail.
It does. Contact, communication. Contact doesn't just mean in person, all right? It means communication. So you can't call her from the jail. You can't talk to her, period.
Man, we have children together. We have 4 kids together. I'm going to have another child for him. How are we supposed to do? How are we supposed to co-parent if we can't talk to each other?
Well, y'all can't co-parent. That's why we're here. Because he assaulted you. He's on probation for felony assault of you. So we're not co-parenting isn't where we're at right now. Right now, we're trying to keep you, that baby, and the rest of your children safe until I know he's following all the rules. He hasn't done the classes that he's supposed to have. He's using drugs. That's not safe for y'all. That's not co-parenting.
Man, I'm going to have another baby.
I'm sorry. There's choices that both of y'all are making, and that's the choice that you're making to still be with somebody that assaulted you. You can go back, go.
Thank you, Judge.
You can go with the bailiff. Good morning, are you Randolph Fines?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Fines, in cause number 25 DCCR 1154, the state has elected to proceed on count 1 only, and in that count to the lesser included offense of a Class A misdemeanor, unlawful carrying a weapon, from June 29th of 2025. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand that?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And are you a U.S. citizen?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Vines is not competent?
No, Your Honor.
All All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of unlawful carrying a weapon. Sentence you in accordance with your agreement to a term of 90 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I feel like this might be one. I don't know all the misdemeanors, but I feel like this is one. Yep. So I'm handing you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. You obviously know this based on what you're charged with, but I'm required to read it. And now I forgot where I was, but lead to charges against you. If you have any questions about what, you should read the document I provided you. I don't know. I lost it totally. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk with Mr. Rojas.
Yes, ma'am.
You can go back with the bailiff. That's what I get for not reading it. I'm reading it in my head. I don't even know where my copy of it is anymore. I've said it so many times. But I can't stop in the middle and then restart. That's not good. All right, this is cause number 25, DCCR 0304. And are you Gerson Santa Maria Mendoza?
Yes, ma'am.
Mr. Mendoza was previously in court, entered a plea of guilty to the first-degree felony offense of aggravated robbery. The agreement was for a 10-year deferred probation and a $1,000 fine. I've received the pre-sentence report. And has everyone had an opportunity to review that report?
Yes.
Are there any additions or corrections? So, Mr. Mendoza, you're only 18, is that right?
Yes, ma'am.
All right, so if I'm going to follow this agreement based on your age, the nature of the offense, the fact that you withdrew from school and haven't completed high school, I'm going to up front send you to the program called ISF. It's a 90-day program, and it is intended to help you to make better decisions. Because of your age, obviously, I want you to be successful on this probation, but I think there needs to be some involvement by other people to help you do better. Does that make sense?
Yes, ma'am.
So I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 10 years. You're ordered to pay the $1,000 fine and follow all of the rules and conditions of probation. That's including going to and successfully completing the cognitive track of the ISF program.
Okay.
If you do everything you're supposed to on this probation and you successfully complete it, this is a great opportunity because you don't have a conviction for a felony on your record. The other side of that, though, is if you violate any condition of your probation,
por regla de libertad condicional,
You can be brought back into court,
no pueden traer otra vez a la corte,
found guilty, so you would be a convicted felon,
y va a ser apelado como miembro.
and you could go to prison for anywhere in the range of punishment, which is a minimum 5 years,
Mínimo 5 años,
up to the rest of your life in prison.
toda su vida en la prisión.
Do you understand?
¿Sí entiende eso? Yes, ma'am.
Also, a condition of your probation is going to be that you get your GED.
Es que agarre su título.
So once you get out of ISF, you're ordered to start that process within 45 days.
Cuando salga, tiene 45 días de completar ese programa. Yes, ma'am.
Okay? All right, I'm handing you the trial court certification.
Está entregando esta también a la corte.
That shows that this was an agreement that I followed,
Una puerta que pues está
so you waived your right to appeal.
solo va a poder apelar su caso.
Okay? Good luck to you, sir.
Buena suerte.
Thank you, Ms. Burge. Thank you.
Thank you, Judge.
They might. You can let them know too. You might be able to start your GED in ISF.
Dice que puede empezar el programa.
So check into it.
Because TDC does have a good program.
Yeah, I just don't know if ISF does, but that would be good to get
That's where
started.
he's gonna be.
Yeah. Okay, let's see.